This is a lecture about Model Rule 3.5, Model Rule 3.5, which is about impartiality and decorum of the tribunal. A lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law, or B, communicate ex parte with such a person during the proceeding, unless authorized to do so by law or court order. I'm going to go through the rules and then come back and talk about them for a moment. C, a lawyer shall not communicate with a juror or prospective juror after discharge of the jury if the communication is prohibited by law or court order, the juror has made known to the lawyer desire not to communicate, or the communication involves misrepresentation, coercion, duress, or harassment, or engage in conduct intended to disrupt a tribunal. And comment 5 notes that this also applies to depositions. And so, so the D one is easy. You're not allowed to do things just to try to get a mistrial, right? Like, don't tell your client, wow, things are really going bad. It would be nice if we had an outburst. So why don't you like physically assault one of the jurors in open court, or physically attack opposing counsel or something like that, so that we can get a mistrial ordered. Don't have your client do that, and you shouldn't do that. But I want to talk about this for a moment, about judges and jurors. And so A means you should get no bribing and no threatening judges and jurors, or prospective jurors, or other related officials, right? A special master, an administrative law judge, or something like that. I think that this is probably pretty obvious, right? The ex parte communication, I want to be a little clearer about. So a lot of my students already know that if you have an adversarial process going on, you as a lawyer are not supposed to like corner the judge at a party, show up at the judge's house in the middle of the night and try and convince them that your case is the just cause, like they do on Suits all the time, on that show Suits, or something like that. So don't approach, if you're going to have a conversation with the judge while litigation about a pending case, the other lawyer has a right to be in on the conversation, right? So we don't want one lawyer don't corner the judge in the hallway or in the elevator or stairwell or something like that at the courthouse and say, listen, you just got to give me a break, or got to hear me out about this. Do it with the other lawyer present, and this could be on a conference call or something like that. And we have some narrow exceptions. By the way, we have a reciprocal rule in the Code of Judicial Conduct that judges are not supposed to have ex parte communications with one of the or the other of the lawyer. And there are some exceptions, right? And small exceptions. One is like for scheduling purposes. So the judge's staff, if they need to bring everybody in for a hearing, they can call one lawyer and call the other and say, please let us know if you can come in on Thursday morning for a hearing, and so forth. But we really shouldn't be talking about the merits of the case. And the other exception is sometimes for purposes of facilitating a little bit of mediation, and it could also be mediation on an issue like whether something will be admissible or whether a child will testify or something like that, the judge could ask the lawyers, is it okay with you if I talk to each of you separately and hear you out about it? And if the lawyers agree, then the judge can. Now, jurors, but generally we're pretty strict about the no ex parte communication. With administrative law judges, we're actually pretty relaxed, I hate to say. And now jurors were even stricter about it, right? Because we're worried that lawyers are going to be overbearing or manipulative. That a lot of lawyers are good arguers and good talkers. And so you're not supposed to even have communications with the jury and with a juror during the proceedings or prospective jurors. And I want to explain to you quickly how strict we are about this. So hypothetically, you go to the courthouse, get in the elevator, second morning of trial. So you had a whole day of trial the previous day, and today's the second day. And who should step into the elevator with you but juror number 2? And they turn to you and say, wow, so do you have some great testimony that you're going to give us today? Or or you did an amazing job yesterday and the whole jury likes you or something like that. And what are you going to say? I can't talk to you, right? You're going to say, I can't talk to you. And you're not going, do not discuss the case. Do not say, wait till you hear the witness we have testifying today. Or, yeah, today we really get into it or something like that. Do not talk about the case. Don't have a conversation. Okay, so that's hypothetical number one. Hypothetical number two, second day of trial, you're in the elevator at the courthouse. Juror number 6 gets in the elevator with you and turns to you and says, can you believe this weather we're having? Or, I cannot believe how hard it is to find a parking space around the courthouse. Something innocuous. They're making chit chat. What are you going to say? I can't talk to you. I'm sorry. Right? Yeah, I can't talk to you. I'm sorry. Why? You're going to get in a big old chat with them. Otherwise, you're going to start saying, I know the weather's been crazy, or the parking's crazy. It's because of the construction or something like that. And I guarantee what's going to happen. The elevator doors are going to open, and who's going to be standing right there? Opposing counsel. And they're going to go right in the courtroom and tell the judge, hey, judge, he's trying. I saw him having a big old conversation with juror number 6, and it was completely inappropriate. I want him sanctioned and so forth, or I want a mistrial and so forth. So don't do it. You're going to tell the juror, I'm sorry, I'm not allowed to talk about the new Star Wars movie. I'm not allowed to talk about the weather. I'm not allowed to talk to you about anything. And in fact, I hate to tell you this, you're not allowed to talk to them about anything. And so even if you're turning to them and say, so let's say you turn to them and say, I'm sorry, I'm really not supposed to talk to you. I'm going to tell you this a little bit of life advice. The elevator doors are going to open, and it's going to be opposing counsel standing right there, and they're going to see you say, wrapping up, I'm not allowed to talk. Really sorry. And they're just going to be like, oh, okay, I understand. And they're still, it's going to look like you're wrapping up a big old conversation. And so I hate to say this, if a juror steps in the elevator with you, you should step out of that elevator and take the stairs. In fact, you should start taking the stairs all the time, maybe. When you're doing a trial at the courthouse, right? You're going to avoid contact with the jurors. If a juror gets in the elevator, you step out of the elevator and take another one. Now, the rule is only about not having conversations, right? But nobody's going to like it. It's going to be awkward for you to say, I'm not allowed to talk to you. They're going to feel snubbed. So why don't you just avoid that and not be anywhere where you could encounter the juror, right? And so the same is true. You take a lunch break, you go to the sandwich deli across the street from the courthouse. The whole jury's going to be in there getting sandwiches. So don't go there, right? You're going to be in line right behind juror number 7, who's going to say, wow, you like ham and cheese too? So do I, or something like that. And then you're going to have a little chat, and a lawyer from the opposing parties, somebody from their office is going to be sitting there watching the whole thing. And so you're going to bring your lunch, right? Or you're going to get in your car and drive across town to another restaurant, avoid the jurors studiously. Now, that's during the proceedings. Afterwards, a lot of times we let lawyers talk to jurors and get some feedback. A lot of times judges, remember, almost half our states have elected judges, they like to meet with the jurors and give them like cookies and tea or something, and biscuits or something like that after the trial, and go around thanking them for their service and oohing and ahhing over pictures of their grandkids and stuff like that. And a lot of times the lawyers want to talk to the jurors and say, you can't reveal the deliberations to me, but tell me like what worked for you, or give me advice, tell me what you liked or didn't like, or things like that. And this can be really useful. You can get really helpful feedback. Also remember that that there are lots of just totally awful people, right? That are gonna, so be prepared for some people to say, I don't like your kind, or to tell you that they don't think you should be wearing jewelry, or that women shouldn't be lawyers, or that they don't like your race, or something like that. There are awful people out there. And if you ask them, why didn't you like us, or what influenced you, you could get a terrible answer, right? And I thought you were too young to be a lawyer. And so watch out for that. But sometimes it's going to be helpful. They're going to tell you something like, just didn't believe the witnesses, or something. And you're going to realize, okay, maybe I convinced myself that the witnesses were believable, and jurors don't like that. Sometimes the judge is going to say, nobody talk to the juror. And guess what? You don't get to talk to jurors. Or if a juror says, don't talk to me, then you are not allowed to talk to them. And similarly, if you leave them a message, you leave jurors a phone message at their home after the case because you're trying to get feedback, and they don't call you back, take that as a sign they don't want to talk to you. And then you're also definitely not allowed to show up at the juror's house and say, you have to talk to me or else, or something like that, because that would be coercion and distress. Okay, D, we already talked about conduct designed to disrupt the tribunal. There's an ABA opinion about this that we're going to talk about in a separate video.